Falana criticizes federal court role in Kano dispute, says it is jurisdictional overreach. Right activist and senior lawyer Mr. Femi Falana San has faulted the intervention of a federal high court in Kano in the Emirship Tussle in the state. According to the senior lawyer, the issues surrounding the appointment and removal of traditional rulers are outside the jurisdiction of the Federal High Court as well as National Industrial Court. The intervention of the Federal High Court in the dispute arising from the disposition of Emir Ado Bayero and Co., as well as the restoration of Emir Sanusi Lamidu Sanusi, is a brazen repudiation of the decision of the Supreme Court, he said, citing the case of Tussle versus Government of Gongola State, 1987. Falana recalled the Apex Court as ruling that the question raised in this claim is not a fundamental right question, because the right to the emir is not guaranteed by the fundamental right provision of the Constitution, and the Federal High Court has no jurisdiction whatsoever in the matter. The Court of Appeal was therefore not in error of law to hold that the Federal High Court has no jurisdiction to grant these two reliefs. He further submitted that since the Apex Court has said that the right to be an emir is not a fundamental right under Chapter 4 of the Constitution, the Federal High Court sitting in Kano ought to have declined jurisdiction to continue to entertain the dispute over the chieftaincy matter in Kano. He added that the allegation of the infringement of the fundamental right of the applicants in an auxiliary claim to the substantive relief emanating from the deposition and reinstatement of the embattled emir. Dear listeners, Mr. Falana, in conclusion, said the judge and the lawyer should realize that the dispute arising from chieftaincies and other local matters are within the exclusive jurisdiction of the High Court of each state of the Federation, notwithstanding that the country is operating a distorted federal arrangement. Therefore, having regard to the facts and circumstances of the controversial decision of the Federal High Court and National Industrial Court on the state of traditional rulers in Kano State, it is pertinent to draw the attention of judges to the case of Tussle versus Government of Gongola State, where Otutu Basi cautioned that court in this country without exemption has no power to prescribe jurisdiction for themselves. Neither do they have power to expand or reduce their area of jurisdiction. Dear listeners, let's hear comment. We have a comment here that says, battle between Gongola and Galadida. Unfortunately, the Kano throne becomes the victim, and Kano people being divided against each other because of two emir in one family. Okay, our judiciary has painted Nigeria black and red, and they don't shame at all. They all themselves be used by evil politicians, and so. Dear listeners, comment on this. Follow us on our page for more updates. Share to your loved ones as we bring you more stories on this. Thank you.